in SEPs and FRAND negotiations managed by IHIPP. So let's dive into this session, which will explore obviousness and damages under Indian laws while applying FRAND principles, featuring insights from speaker's published paper on lexology. Our moderator, Dr. S.K. Murthy, co-founder of IHIPP and founder of Satatam Kritam Legal Solutions. Welcome, sir. Joining him is an exceptional lineup of speakers, each bringing a wealth of expertise. Firstly, we have Mr. Naren, founder of IP Horizons, a patent firm based out of Bengaluru with expertise both in the United States and India. He has worked at Intel and top US firms. He holds degrees in engineering, computer science and law. Welcome, sir. Next, we have Mr. Johan Lianag, from Linklaters, an expert in cross-border patent disputes and IP-driven transactions. He advises clients from Johnson & Johnson, Siemens, Nokia and supports biotech firms. Welcome, sir. Finally, we welcome Ms. Saya Chaudhary Kapoor from Singh & Singh, specializing in patent prosecution, litigation and competition law. She leads a team handling landmark SEP disputes and FRAND negotiations. Welcome back. Over to Dr. Murthy to moderate this session.
Hi, good afternoon.
Dr. Murthy, 1 second. So just a quick announcement. Post this and the next session, we will be having an award ceremony taking place at Hall 1. Thank you.
Thank you. Standard essential patents, standards, interplay between patents and standards and competition law is a fantastic field. And just to give you a sense of how many standard essential patents are involved in one of the leading standards of 3GPP or cellular standards. If we put 3G, 4G and 5G together, there are more than 1 lakh standard essential patents. Right? And the number of standard essential patents which were embodied or which covered 3GPP, and if we compare those patents with the number of patents or patent applications covering 4G and to 5G, there is kind of an exponential increase in the number of standard essential patents. And as the number of patent assets covering the standards are increasing, the complications and the issues and challenges are also increasing. And to add to this, there has been quite a number of cases, court cases throughout the world. There are around 170 cases or so related to SEPs, right? And having 170 cases related to SEPs is not an issue, but the outcome that comes out of the court or the judgments that comes out of the court are kind of swinging the pendulum in the opposite way. So that makes it difficult for people who are contributing to standards to understand what should be the policy and companies to form their strategies. So today we have an excellent panel. We will talk about some of the challenges that we have related to SEPs and how FRAND, implementation of FRAND is really difficult because FRAND does not have a definition today, though it can be expanded as fair, reasonable and non-discriminatory. There is no specific definition of what fairness is, what discrimination is or non-discrimination is, and so on, and what could be the reasonable royalties, all those things. So we'll talk about all those things and also put this in the perspective of different geographical jurisdictions and also the court cases that are happening in these jurisdictions. So we'll start with Saya first and look at what's happening in India, then we'll move on to Johan to look at what's happening in the Europe, and also you can bring in perspective from other geos. And then we have a very interesting twist to the story. And The twist is in the form of confidentiality agreements, and of course, Naren is here to talk about confidentiality agreements and give his perspective on how these confidentiality agreements play a role when it comes to SEP arena. Okay? With that, Saya, for your prepared remarks.
Thank you, Dr. Murthy. Good afternoon to my fellow panelists, ladies and gentlemen. In my opening remarks, I would just like to give a summary of what the legal position is in India as far as SEPs is concerned. India as a jurisdiction has seen evolution in its SEP jurisprudence as far as other nations are concerned. The courts have molded the relief, not only taking into consideration the peculiar nature of SEPs, but also the realities of India as a nation. Now, this has come to light in cases such as Ericsson and Intex, and it was subsequently reiterated in the case of Nokia and Oppo, where Justice Manmohan specifically observed that we can't lose sight of the fact that in India, the judges to population ratio is quite low, and it takes time for trials to be conducted, for final hearing arguments to be heard, in fact for even interim injunction arguments to be heard. And it was this observation that sort of gave rise to the importance of quorum arrangement, which we see that are being put in place at the interim stage in cases relating to standard essential patents. And while sort of explaining about that and propounding about that, Justice Manmohan observed that the reason that we need to bring about these pro tem arrangement is because of the very nature of standard essential patents, right? Because when parties negotiate, the proprietors and implementers are negotiating. Throughout that process, implementer is using the patented invention. Even during the course of litigation, the implementer is using that patented invention. Of course, there are issues relating to essentiality, there are issues relating to whether there is infringement or not, but it does create a sort of asymmetry. So in order to balance the equation, there ought to be some sort of security that ideally should come in at the stage of negotiation, but then at least when the matter comes to court, at the stage of litigation, a pro tem security must be put in place. And he observed that an inaction on part of an implementer is something which is unacceptable. And at least as far as India is concerned, injunctions can be granted even at an interim stage. So one patent will act as your silver bullet, and courts will look into patents and grant injunctions if you're an unwilling licensee. So conduct becomes very important from the perspective of both a proprietor and an implementer. He also recognized that SEPs have been given a recognition in Delhi High Court patent rules, and it sort of lays down the protocol which is required to be followed both from the proprietor and an implementer perspective. So what you're required to do when you file a suit and what you're required to do when you're defending it. And all these observations were then subsequently sort of relied upon and followed in the Ericsson Lava matter, which was the first judgment to come out post-trial, which dealt with issues of FRAND. And in that particular case, Justice Bansal sort of held that damages in SEP litigation can be asserted by relying upon FRAND. Now, he observed that FRAND can be arranged and parties that are unwilling licensees, the upper end of FRAND can be applicable. Now, there are other aspects also which he clarified. I mean, he laid down the test of anticipation, 7th down. And for the first time in India, inherent anticipation was brought in as one of the steps to test anticipation. Section 3K, which is a peculiar section as far as India is concerned, he clarified that algorithm is, there is a complete bar to grant of patents for algorithm. But at the same time, just because algorithm or step-by-step process forms a component of an invention does not mean that you refuse to grant a patent. So you need to analyze every patent on a fact basis and see whether an invention is liable to be granted, and that analysis needs to be done in every case. So this is the current legal position, and also at the final stage he says that it's really important to look at the conduct of the party to determine whether a party is a willing licensor or a willing licensee. So conduct per se is very important as far as Indian litigation is concerned in order to determine whether injunction would be granted or not, and yes, injunctions are granted.
Thank you very much. So what I wanted to do was try and describe some of the recent developments in Europe and draw some themes and trends from them. And I'll talk first about the UK and then about the new Unified Patent Court. Both of these courts have been very busy, so I can't really cover everything that's happening there. In the UK, we now have 3 decisions from the UK court which have actually set FRAND rates. The first of those was the very famous, well-known decision of Unwired Planet and Huawei in 2017, that then went up to the UK Supreme Court. It was then very quiet from decisions. There was a lot of cases happening, but they largely settled. But then 2023 was a significant year with 2 further judgments in InterDigital and Lenovo, and then Optus and Apple. And the InterDigital case also then went up to the Court of Appeal. So we've now had 3 first instance decisions, 3 appellate decisions. So we've got a more established body of law about how to set FRAND rates and the process that we go through. We can go through some of the more details. But it's significant now. I think we have greater clarity, greater certainty as to the approach of the courts. And the other big trend in the UK is, having started off as perhaps more SEP holder friendly, it's become more of an implementer friendly jurisdiction. So in the first case, the Unwired Planet case, the rate set by the court was much closer to what Unwired Planet, the SEP holder, had suggested than Huawei, the implementer. In the 2 more recent cases, that position has flipped, and the rates set by the court were much closer to what Lenovo and Apple had proposed. So that has actually led to a lot of implementers coming to the UK to start cases there. And the courts have also said in another development that it is okay for the implementer to come and start the case. They don't have to wait to be sued, as happened in the early cases by Unwired Planet. And the other development in the UK, it's interesting actually, having just heard what Saya said, is interim relief. So that's relatively new for us, but it seems to be more established in India. So courts are willing now to grant interim licenses while there's the main determination of the FRAND rate. That came up in the Panasonic and Xiaomi case just from November of last year. There were UK proceedings ongoing. Both parties had agreed to abide by the court's decision on FRAND. But simultaneously, Panasonic was suing Xiaomi both in Germany and at the UPC. And those cases were going to move faster. So there was a prospect of being injuncted before the UK global rate. And Xiaomi kind of rightly said, well, are you really a willing licensee, a willing licensor on a global basis if you're offered another court trying to get injunctions? And the Court of Appeal ultimately agreed with Xiaomi and said that Panasonic had to enter into an interim license. So there's very much a trend in the UK of becoming more implementer friendly. And then contrasting that position in the UPC, so as many people will know, we have a new court in Europe, the Unified Patent Court, possibly the most significant development in patent law in Europe since really the European Patent Convention over 50 years ago. That launched in the 1st of June 2023. The first year of decisions was largely interim decisions, as you would expect, but towards the end of last year, actually just in the last 2 months, we've had the first 2 FRAND defence decisions. And the UPC court is following the German approach and the approach set out by the Court of Justice of the European Union in Huawei and ZTE. And that, as Saya described in India, is very much focused on the conduct of the parties. Have they willingly, or have they agreed to enter into licenses on the terms set by the court? Are they conducting negotiations in a fair and FRAND and reasonable manner? And in the first 2 cases from the UPC, that court has found in favour of the SEP holder and granted injunctions against the implementer, saying that their conduct was not appropriate. Although they said that they were willing to enter into a license. Their conduct showed that they weren't genuinely willing, they weren't providing the information, they weren't engaging in the negotiation. And as a result, injunctions were granted. And because this is now a cross-border court, it was in Panasonic and Oppo, there was an injunction in 5 countries across Europe, and in Huawei and Netgear in 7 countries. So a lot to play for when you are litigating at the UPC. So in contrast to the UK, the UPC actually seems to be very much a SEP holder friendly jurisdiction. So I think in the coming year, we're going to see this balance between the UK and the UPC, with perhaps implementers rushing to the UK, and then the SEP holders rushing to the UPC.
I can go there. Yeah. Please do go away. So, I am first let me thank the organizers for giving me this opportunity to speak to you all. Thank you, SK, for inviting me also. I am an engineer and I understand patents very deeply. And my presentation is going to address 2 questions. Is the confidentiality provision of 3GPP lawful? And the second question is, does an individual SEP merit injunction? These are very fundamental questions. I mean, all of us will agree patent protection is important for progress of technology and life. But if the patent protection is more than justified by policy, it may or may not help countries like India, which are more developing countries. So these 2 fundamental questions need to be understood more in the India context, and I will try to dig deep into this question. So first, the slide is now, since the first question was about confidentiality provision, this is the reproduction of the literal text. What all this is saying is, you don't need to understand it, but basically they're saying in the 3GPP process, if somebody submits a document and they mark it as confidential, it will be confidential forever unless their proposal is accepted by the committee. All right, so if you submit a proposal and it gets accepted, it becomes public. If it doesn't get accepted, it stays confidential. That's what it's saying. All right. So let's understand how the 3GPP standard development process works, how without this confidentiality clause, how patent law would work, how this changes the way we analyze patents, right? So the nature of 3GPP standard development. So basically, the way this whole thing works, first somebody has to develop the hardware, how to use the medium. These are very early. Unless these capabilities are there, you won't have a working product. So typically, 3GPP process starts to build the coordination. My issue is only, or rather the presentation addresses only those patents once the 3GPP starts. Until then, I agree that it's a very fundamental science, maybe the merit of which we cannot question. But after that, when 3GPP gets together, right, and my belief is about 75% of SEPs are granted after the 3GPP starts. So let's understand the 3GPP process. If you have to design it, there's no other way to do it. So basically somebody says, the experts sit together and say, here are the top down, here is the top area, let's break it to 30 topics, this 30 let's break it into another 60 topics each, and each topic gets given to a working group. So anybody in the world going through the standard development organization can get in and make a proposal. So when they make a proposal, either by consensus or if necessary by 70% of voting agreement in occasional cases, a proposal becomes accepted to be a standard, right? So
So these are very detailed documents. They discuss interactively and then they vote, all that. But remember, what did the confidentiality agreement say? If it doesn't get accepted, it's confidential, right? So these standards go on for a year, 2 years, I don't know, very long. It's not a one-day affair, right? So the challenge is I'm looking at that period when the 3GPP starts versus until the standard completely is developed, which could be many months or years, right? So my question is, see, if you didn't have the confidentiality agreement, all of those documents are public domain. So if they are public domain, the consequence of that is, right, each of your patent claims gets examined against all those documents, which makes it significantly less probable that later submissions will be patentable. It's not just that. See, they think 2G, 3G, 4G. In 3G, the documents that would have been submitted, if they are not all prior art, right? So the question becomes, right, should somebody have a proprietary right saying when they give to the standards committee, right, they have an expectation of confidentiality, is it legitimate? I don't think so. See, these are the reason I say that. Okay, let's go look at this slide. Okay, so let's, now hopefully you have a mental picture of how the 3GPP standard development process works, how removing some of these documents as prior art would make it easier for more patents to be granted, right? So now let's go back, step back and understand what is patent law. See, patent law, this is something I keep saying. It's not a certificate for getting there first, 200%. The more appropriate way to understand a patent is always, if the technology won't reach the public otherwise, I will grant a patent. If something is on the path to getting there, it is obvious. That's what courts in India or US have consistently clarified, right? So, so inclusion and exclusion of a prior art. There is prior art, how many documents can be there? And if you think even the oral way of what they say is also prior art, there is a legitimate argument to be made that it should be prior art. It actually explains the mental process which can be the basis for obviousness analysis. If any of you have prosecuted an actual software case, most cases you are not arguing this is not there. You are arguing because the way I have combined, it's not there. But if you have removed the mental process the committee has, earlier committees have gone through from prior art, it cuts off the obviousness analysis, right? So patents in telecom domain. Now understand this. The other panelists also were explaining these buzzwords. Predictable arts versus unpredictable. Medicines, drugs, all those, they are unpredictable. A little change can cause significant changes, but telecom, it's predictable art, meaning you know what software if you implement, what output you'll get. There is no surprises, right? Telecom is predictable art, don't forget that. Each submitted solution is only according to established principles. There is, so basically one will be able to make an argument, right? If somebody tells this is what needs to be done, right? There will be 20 people who can give a proposal, a written proposal, right? Because it's all according to established principles, right? So incorrect to equate telecom patents with unpredictable arts. If you see some of the respect we show, we hear from people, especially coming from the chemistry and medicine kind of backgrounds, they show a much higher deference to patents, which may or may not be appropriate when you look at the telecom kind of patents. So this again, remember, so there is enough case law which says if something is on the way, don't grant it patent. This whole standards development process is approved by the governments. It's backed by the governments. The dynamics are started by the governments. It's in the process. right? There is, it's very difficult to say there isn't expertise that would not be available without the extra patent protection that you get by removing this prior art, which, well, due to this confidentiality agreement, right? Like I said, it's driven by collaborative efforts of all countries, so there is not that much risk as in a pharma or a chemical kind of process. And like I said, majority of the patents are filed during in the period of standard development. So materiality of excluded prior art, like we established because of the confidentiality provision, certain information within that 1-2 years, which would otherwise be prior art, is not prior art, right? So non-accepted submissions by bottom line submitters, like I said, it's competitive, 20 people may give proposals, so 19 of them don't become prior art. Potentially many more insightful documents. See, again, these are according to established principles, right? This is not like medicine where somebody has given a trade secret, highly valuable trade secret. Like I explained, across 3G, 4G, documents in 2G would have been withheld as confidential because they didn't get accepted. Here is the crucial thing, the thing to remember. See, the notion of patent act is you're rewarding an individual inventor or perhaps an organization, right? But when you're taking help from others, it is prior art, right? So in the name of a confidentiality agreement, the benefit the inventor has received is not being considered to reject a patent claim. So I want us to remember all this in detail. See, this when you exclude this prior art and the mental thinking that would have gone in the other earlier process, the documents, remember this relevance is magnified in predictable arts because it's all about established principles. So it's relevant to skill in the art, and also it's relevant to motivation. What do I mean by skill in the art? Here is the question. If the same problem was given by somebody and 20 people gave the same proposal and one person's thing went through and 20 people, if there are 20 similar submissions, what is unobvious about it? The patent office should have access to all the 20 documents before they grant a patent to any one of them, because these are all dynamics that are approved by the government. Necessarily following from governments collaborating to develop a standard. So here are the, if you understand all of this, now here are the legal practical questions presented. Does the confidentiality agreement clause impermissibly redefine patentability criteria? Oh, I can see that. Does the confidentiality clause impermissibly redefine confidentiality criteria? See, Patent Act is the higher power. Now suddenly an agreement, private agreement that's imposed by 3GPP, can it override the national laws of the 300 countries? Does the 3GPP confidentiality clause violate competition law by providing for more patents or monopolies than that contemplated by the Patents Act? See, the Competition Act, all the other judgments, they didn't address this question. So if the confidentiality clause is incorrect, it has allowed more patents. Maybe that's the reason why we have the 1 lakh patents for a technology that shouldn't have as many. Is the confidentiality clause by contract? Why does it against public policy? A lot of courts strike off agreements. This whole confidentiality clause is by agreement. There is no supervening law, right? This is the last question. Does the 3GPP need to concede that much to the innovators? It's a question, fair question to ask, right? Cannot equate to, like, somebody could say, hey, this is an IEEE submission, we borrowed it from there. IEEE papers are totally different. You're submitting for dissemination of knowledge. You're not giving it for a functional purpose for the entire world to use. So that equation should not hold water. Similarly, I mean, I've heard, I mean, when I presented this, oh, we do this in some of the private kind of committees where we are developing technology to keep it confidential. That's okay, see, that's private effort. Here, we are talking about a globally sponsored government effort. See, primary function is to set the standards, not patent contributions. Standard developers would have, I mean, I'm saying standard developers would already have sufficient lead in a product, even if you have fewer patents. So the patent law purpose would still be served if the confidentiality clause is not there. So here is, I mean, this is my favorite table I try to put into any patent law discussion. See, again, this is the point I try to make. I mean, somebody who has their heart out for unpredictable arts, because suddenly they put the SEP or telecom patents in the same level. I try to give this table. It's very interesting. See, number of patents granted. See, in telecom or in the functional space, for a given product, if you take iPhone, there are 6,000 patents. In medicine kind of area, one patent, one. So it's more respect. See, the level of experimentation required. See, in software, it's a self-contained organization does it itself. Whereas in pharma kind of area, it's the clinical trials, the amount of effort it takes to correct and the experiment is a lot. So, if when you have 10,000, I mean, 1 lakh patents in a product, for one patent, if you are going to stop the entire product from being sold, right? What about your Article 19 kind of rights, right to live for this 999 patents? It's a question that needs to be thought about. That's all I have. Thank you.
Okay, we'll get back from confidentiality agreements back to FRAND and how FRAND rates are determined in Europe.
So in Europe, it's very much based on, or in the UK, it's very much based on comparable licenses. So each party will put forward their favourite comparable licenses, and the court will use that as a basis. It then does a kind of top-down cross-check, so it looks at the aggregate royalty payment across the whole standard, and then extrapolates or narrows that down for the number of patents that the licensor has. But generally, it's done by comparable licenses.
In India also, in the Ericsson case, the judge looked at the comparable licenses. In fact, Ericsson relied upon the comparable license approach, whereas Lava propounded that it is relying upon a top-down approach, whereas what they relied upon was patent pool rate. So in a sense, it was sort of, they were comparing an existing patent pool rate, was sort of a comparable license approach. But ultimately, the judge agreed with Ericsson, so he went with the comparable license approach. And on the FRAND aspect, he agreed with certain sort of go-to provisions. He agreed that portfolio is FRAND, global licensing is FRAND. He agreed that asking for a patent by patent and country by country license is not a FRAND approach. He agreed that you can't ask for a license only for certain models which have been tested. It will be granted for all the matters, for all the models or all the devices pertaining to the technology for which the suit has been filed. So all of these aspects and issues were sort of clarified by the judge. And he also indicated that the license or the damages which would be granted by the court would run from the day on which the patents were published under Section 11A7 of the Patents Act. And the only defense then an implementer can raise is that he was unaware about the patents. So at least from the very day the first letter was written by the proprietor to the implementer. So you can ask for back damages as well.
Okay. A follow-up question to that. What factors have gone in favor of comparable licenses as compared to SSPPUs and in-device?
So definitely SSPUs, smaller scale practicing unit is not the approach. So the courts have done it either on a royalty basis for the whole unit or a fixed price per unit. And that's the approach that seems to be taken more recently. As in India, a FRAND rate is generally global. And there's been some sort of commentary on what the non-discriminatory element of FRAND is. So in the Unwired Planet case, the SEP-holder Unwired Planet, during the course of the litigation against multiple defendants, was running out of money. So it settled with Samsung at a low rate. But that didn't mean that it had to settle or that rate was FRAND. It could agree to a sub-FRAND rate just because of the circumstances. So it's not a most favoured nation, a most favoured licensee clause. And then volume discounts are not FRAND, but they are quite common in negotiation, but the courts have held that they end up being discriminatory because obviously it would discriminate against a smaller player.
Okay, from an Indian perspective, especially related to SEPs, we have something known as confidentiality clause. What is it trying to solve? What is the challenge that confidentiality clubs are trying to solve?
So
And is it unique to India?
no, I don't think that confidentiality clubs are unique to India. We've seen that in UK as well, and in US and other jurisdictions too. In SEP cases, while dealing with aspects relating to what is fair, reasonable and non-discriminatory license fee, specifically when you're looking at comparable license agreements, which are third-party license agreements, and which pertains to licenses which have been entered into or executed both by proprietors and implementers, which they believe are confidential. These clubs are created where limited members have access to these agreements. Also from an implementer's perspective, they believe that details of their sales, that the quantum of devices they're selling, the sort of type of devices that they're selling, their future selling plans, etc. They also regard that as confidential information, and they're not willing to sort of share that with the plaintiff or the proprietor. So even for that purposes, confidentiality clubs are created.
A follow-up question to that. At some point in time, non-disclosure agreements were the basis of implementers going to corporate CCI. Would confidentiality club address that question?
See, as far as the CCI aspect is concerned now, in the judgment that has come out, I mean, it has been clarified that it's general common industry practice to enter into NDA, and that's not abuse of dominant position to start off with. Now, as far as confidentiality club is concerned, yes, it does address that because your lawyers, your economic experts, and now also a member of the industry, your particular company who is not regularly involved in licensing does get access to all those agreements and information.
Thank you. In Europe, there is a SEP regulation that is coming up. Of course, I know it is not set in stone yet. What are your thoughts about SEP regulation and the way in which it is progressing?
Yes, so that was proposed by the European Commission in April 2023, to much fanfare, actually after it was leaked. And it's quite a sweeping proposed reform, very implementer friendly. So it's proposing to have a new register of standard essential patents for each standard, and if you don't register your patent, the penalty is that you essentially can't enforce it. You can't enforce it, you can't get injunctions, you can't get damages. Also proposal that the EU Intellectual Property Office will conduct essentiality checks on standard essential patents. And then most significantly, it is proposing a FRAND determination forum. So you have to go through this mandatory process that would last 9 months before you can assert your patent in national proceedings. So it was proposed by the Commission, it went through the Parliament with a narrow majority, and it's now with the European Council where Member States can comment on it. And some Member States are opposing it, so in particular Sweden, Finland and the Netherlands. Not a coincidence that those are the countries that Ericsson, Nokia and Philips are domiciled. So they are looking to block it. And I think a lot of countries are a bit ambivalent about it. They feel that the market is functioning. Yes, there's a lot of litigation, but from a consumer perspective, this is an area where there's been a huge amount of technological development that has led to improved technology at a price that consumers are willing to pay. So why should we regulate something when the market is functioning? So there's a feeling that the legislation will actually get stuck in the European Council. The last president, which was Hungary, didn't pay much attention to it in its presidency, and the new country, which is Poland, is also saying that it's not very interested. So despite the fanfare, I think it's something that might end up sort of withering on the vine and not coming into law.
I read the comments very briefly, and we have a very clear line drawn. There is one group which is clearly supporting the SEP regulation, and there is another, and both have very valid points. And I don't know, the job of a policymaker is very, very difficult when you have valid points on both the sides. Thank you very much for that. Naren, based on your presentation, are you suggesting that the confidentiality clauses in 3GPP partner organization should change? And if yes, what those changes should be?
There is no reason, as far as I can see, to impose this confidentiality clause when patent system itself addresses what we need. So it must be struck off, at least for future standards. And as far as I'm concerned, if I were representing a defendant in India, implementer in India, if I'm taken to a court case, I would present this to the judge that all these patents have been granted on a very imperfect basis. I don't know what the remedy is. Maybe ask the the SEP holder to explain how much information their inventors have gotten and have the case re-examined under India law. Yeah. But as far as I'm concerned, 3GPP has introduced a complexity that was not required, and it can be addressed somehow. I don't know how the litigation strategies work, but as far as a theoretical patent philosophy is concerned, confidentiality clause, in my view, should not stand, cannot stand, and it has wrongly interfered with the patent principles.
Would it demotivate the participants coming into standards and forming the standards? Today we have SEP holders, innovative companies who come into standards formation and standards bodies, and they contribute. Once there is no confidentiality clause, would it demotivate?
No. Basically, see, you are saying you get a patent for what you contribute. Whatever you are learning from the 3GPP process must be prior art, and that should reduce the number of patents and the complexity the implementers have to use. I'm not saying patents shouldn't be there with the 3GPP process. I'm simply saying the patent law already operates in a particular way to define what should be prior art, and it's wrong for 3GPP to have introduced a confidentiality clause which removes what should be the most material prior art in examination of SEP patents. There is nothing more material than the discussions that happen in 3GPP, and that's what I'm clarifying. It's not like medicines kind of area where they're giving a working chemical formula. This is information based on somebody who has given a prompt according to established principles, which arguably is a FOSITA. They are simply giving a FOSITA answer. The patent law really is giving advantage of even some of the FOSITA implementations to the extent they're not shown in the prior art. They're giving the benefit of patent grant to the functional space. It does not mean now you need to get more.
Thank you. Any closing remarks, Saya? One statement.
One statement. I think SEPs is the field to watch aside from AI as far as patents are concerned.
Okay. Yeah, I think likewise, as I said earlier, it's the field to watch, and I think it's going to be very interesting in Europe to see the battle really between these conflicting forums of UK, which is implementer friendly, and the UPC, which seems now to be very SEP holder friendly.
In my view, patent law will be strengthened if you grant fewer patents for more meritorious inventions, and confidentiality clause is going against that.
Thank you very much. Time's up, but I can allow one or two questions.
I have one question on the SEP license holder giving licenses to the multiple entities for the same thing. For the same SEP patents. So, suppose there is a OEM, he is taking some part from a supplier or a vendor, is implementing that part in his larger device and using that in that larger device. So he is not the manufacturer of the part taken from any supplier. He is taking that part using in a larger device, and now sometimes the SEP patent holders are asking to take licenses to a person who has put that part in a larger device. So my question is it okay? If not okay, then whether it is now becoming a choice of the SEP patent holder to whom they can ask for a license. In this case, the last user who is using that part and putting in the larger device, so he thought like I have taken a part from a supplier and it's like a between us, so I don't have any liability on those things. But now once he implemented that part in a larger device, now the SEP patent holder says that you have to take a license from me. Because I don't know whether you have taken from somebody else or no. It is in your larger device, so you have to take it. So I love your thought on this.
Yes. So as far as the infringement provision in India is concerned, right, a patentee can sue an entity who uses a patent, right? So if you are, ultimately your device, the larger device, uses the patent, so a patent owner is in his or her right to sue you. The second aspect is when you are procuring any sort of component, there must be some aspect of due diligence involved, that whether it entails any infringement of any sort of proprietary, whether be it patent, trademark, copyright, trade secret, any sort of IP right of any third party, that must be conducted as a diligent party or entity on your part. If there is a license, as Dr. Murthy said, then definitely you can take the defense of exhaustion. Patent law does sort of recognize that. Specifically as far as SEPs is concerned, it also depends on what is the finally granted claim. Does it read on the end user device? And in India, as far as telecommunication is concerned, it has been recognized that licensing at end user device is fair, reasonable and non-discriminatory. So if a party or an entity and an SEP proprietor licenses a handset, that's okay. And even courts, when they fix license rates, they tend to do that at end user devices.
So here, like suppose that particular part manufacturer has taken a license from the SEP holder. So whether now in that case the larger device holder is still responsible?
If they have taken a license, then you can plead exhaustion, then you're not required to pay. Because SEP proprietor can't double dip. It can't charge the smaller device, the component manufacturer, as well as the larger device manufacturer, if it's for the same patent. For one patent, the proprietor can't charge twice over. So exhaustion will kick in.
It all depends upon the licensing agreement, on what terms and condition agreement has been given, and also claims, whether it pertains to one specific claim or whatever it is. It all depends on the agreement. It can be exclusive, non-exclusive. When exclusive, we can give to n number of people down the line, without any issue. It all depends on the agreement content.
Following on from the discussion about SEPs and regulation, my question specifically is regarding the regulation of SEPs, or rather how a lot of people are calling it as over-regulation of SEPs in the Europe. Mr. Yuan, you specifically talked about how countries like Finland, Netherlands, and Sweden are opposing the legislation in the European Council, and a lot of the argument that they come up with is this over-regulation would lead to less innovation in the future. Because, but the argument from the European Union overall is to protect the rights of consumer, and yeah, overall this should not stop innovation. And all American companies are also sort of like not in good, not saying a lot of good things about this over-regulation. What is your view overall? Would such a regulation stop innovation, or is it just the companies that are, let me call it, in an oligopoly market, controlling a lot of SEPs, trying to play their part?
Are you asking for this?
Yeah. Or maybe other panel members can also talk about that if they have a viewpoint. Thank you.
Yeah. Well, as I said, as I mentioned earlier, there is a feeling that amongst many that the market is working fine for consumers, so there is no need to regulate.
It's also working very good for these 4 or 5 firms.
Yes. Yeah. So my own personal view is I don't think the regulation would lead to a change in innovation. I think it might just lead to a change in litigation practice, but I don't think it will end up sort of disrupting or changing the economics of the market.
So my question is related to FRAND rates. So let's take an example. So assume that there are 2 implementers, implementer A and implementer B, right? And implementer A and implementer B, both of them they don't have any SEP. They don't own any SEP. So now, when we talk about FRAND rates, right, from an SEP, the FRAND rates to be paid to an SEP holder. So if the FRAND rates are fixed, then does it mean implementer A, whatever rate he is paying to the SEP holder, is same like implementer B, or this can vary? And if it varies, in what circumstances it varies?
Okay, so if you don't have any patents to cross-license, right? Then the only scenario, ideally, in which it can vary, it depends on your product mix. If you're offering product A, which is different from product B, but if it's identical product for a fair, reasonable, and non-discriminatory license, specifically taking into consideration the non-discriminatory aspect, and I'm talking about all the other scenarios where you're in the same market, the price points of your devices are identical, it's identical technology, you're operating in the same timelines, then yes, identical rates are to be offered. But if any of these factors, like your markets are different, your product mix are different, your technology mixes are different, then there might be different rates which might be offered to different implementers.
Yeah, but the question here is the SEP holder's patent, right? The same patent is going in both the implementers, and that is not changing the product differentiation of implementer A and implementer B. Implementer A and implementer B may be using some different technology or different differentiation which has nothing to do with the SEP holder, right? SEP holder's patent is common to both implementer A and implementer B.
Suppose, I'll give you a very simple example, right? I think we're running out of time. We can discuss this all.
The short answer is no. cannot differentiate. One of the exceptions will be, in your example, if implementer B is selling 100 products, 100 numbers, and if implementer B is selling 10,000 or 10 lakh, if implementer B is selling 10 lakh units per month, then there, based on the volume, there could be, but the answer is not a definite yes, right? It is still contestable, right? But that could be one of the corner cases where you can look at the volumes that is sold by these implementers and give some changes in the royalty rates. Other than that, I don't see any other reason.
Well, I think in Europe that wouldn't be permitted because that would be considered discriminatory. If you were doing it based on the volume, because that would discriminate against smaller implementers.
Okay. With that, we will close the session. Thank you so much. Fantastic audience, fantastic panel. Thank you.
Thank you all for that very engaging session. I'd like to request Dr. Murthy to please felicitate our speakers. We shall start with Mr. Naren, founder of IP Horizons. Next, Mr. Johan from Linklaters. Miss Saya from Sing and Sing. I'd like to request all speakers to assemble for a group picture. Requesting Dr. Agarwal to please join the speaker.